A few weeks ago, I did an episode on the recent ruling in the Adamson BBQ Limited case, and I made the argument there that there's no evidence of corruption in our judicial system from what had been reported on that case. And if I didn't explicitly promise, I suggested that I'd take a look at the actual decision once I had access to it. So today on Don't Talk TV, I've got that decision and some other supporting documents. We're going to have a look at that. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Today's been just one of those days, but I know you're expecting a video, and I think a few viewers at least have been waiting to see the actual decision on the Adamson BBQ case. So we're going to have a look at that. This may not be the most polished video ever, just I'm at the end of the day after a crazy day in court trying to put this together, but I don't want to leave people waiting any longer on this. So you can watch the video that I did a few weeks ago, but just as a really brief recap, what the National Post article I looked at was saying was that the judge had said she lacked jurisdiction because the lawyers for Mr. Skelly had not put before her a proper constitutional question upon which she could rule. And I said that in my view, she's completely right. You have to have that originating document. You have to be asking a judge for a remedy in order to get that remedy. So now that I've got the actual case, we'll go through it. I'll give you the short version up front. I think the National Post was quite accurate in their portrayal of this case, and I stand by the comments that I made at that time, but let's look at the actual case. I'll try to do it as quickly as I can. So we've got here the case, Her Majesty the Queen in right of Ontario, and Adamson BBQ Limited and William Adam Skelly, the owner of Adamson BBQ. I think this is important right at the beginning. The court gives the context to what's going on here. So this is in relation to a judgment delivered by Justice Kimmel, which was issuing the injunction that ordered Adamson BBQ to be closed. So it says here, paragraph 2, Justice Kimmel's reasons, released on December 11th, 2020, contemplated a, quote, comeback motion, unquote. The comeback motion was expected to be an opportunity for the respondents, that being Mr. Skelly and Adamson BBQ, to seek to have the restraining order set aside, varied, or terminated on the basis of a challenge to the constitutionality of the legislative scheme. The respondents argue that what came before me on June the 28th, 2021 was the comeback motion. However, the motion did not seek to set aside, vary, or terminate Kimmel J's order. Rather, the respondents brought an interim motion without any originating process, seeking a final order for damages under Section 24(1) of the Constitution Act 1982. So let's have a look at the documents that were actually filed in court. So here's the motion filed by Mr. Skelly's lawyers, and let's have a look at what it says. So we can see it's an amended notice of constitutional question. So this is their updated application, and here's what it asks for. The applicants, Adamson BBQ Limited and William Adamson Skelly, intend to question the constitutional validity and applicability of the Reopening Ontario Act and claim a remedy under Section 24 sub 1 of the Canadian Charter of Rights and Freedoms in relation to acts and omissions of the Government of Ontario. But the question is to be argued on a date at the direction of Justice Kimmel, and then they start going into the facts, and they give a bit more detail later on. And on page 7 here, they go into a bit more detail of the constitutional questions that will be put to the court for consideration. And then they outline the questions. I won't go through those in detail. It's clear that the questions, the constitutional issues, were very clearly laid out. But as you can see, there's nothing in there about asking for the injunction to be set aside, asking for Mr. Skelly to be allowed to reopen his business, or even asking for the Reopening Ontario Act to be thrown out. There's a quote generally that they would be seeking a remedy under Section 24(1) of the Charter of Rights and Freedoms, but Section 24 sub 1 is quite general. Specifically, it reads, anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Under 24(1), you can ask for a variety of different things, including asking for the Justice Kimmel's order to be set aside. So going back to Justice Akbarali's decision at paragraph 33, she outlines some of the law that she's relying on in making her judgment, and she quotes here the case of Zargar and Sarabian, a 2018 Ontario Superior Court decision, and the court at paragraphs 15 to 22 of that decision wrote, "Parties should not have to guess, speculate, or intuitively understand what the issues to be decided are on a motion. In an adversarial litigation system, it is imperative that the litigants are made clearly aware of the case they have to meet." And then Justice Akbarali goes on to note at paragraph 34, "As I have noted, the only substantive relief sought in the March notice of motion is for charter damages. If the respondent seeks any relief beyond charter damages on this motion, their notice of motion runs afoul of Rule 37.06, which requires that every notice of constitutional motion shall state the precise relief sought, state the grounds to be argued, including a reference to any statutory provision or rule to be relied on, and 3, list the documentary evidence to be used at the hearing of the motion." I think 2 and 3 were clearly made out. The application on a whole is very well written in my view. Not that Mr. Scully's lawyers care about my view of whether their materials are well written or not, but for viewers of Don't Talk TV, you're probably wondering what I think. I think it's very well written, but I think that from what I've shown, you can see there's no precise relief sought, and that's just simply what the rules require. And I go back to what I've said in my last video and what I've said in a number of videos about the rule of law. This is how our law works. The rules are the rules, and we all have to follow them, whether it's the state or whether it's another individual. And we, accused people or people challenging the charter, have to follow the rules because the government needs to follow the rules. So in my view, we want the system to be one where everyone follows the same rules. And then it goes on here, paragraph 37, the judge further clarifies, neither notice of motion, neither the first one nor the amended one we've looked at, ever sought an order setting aside the legislative scheme based on its alleged unconstitutionality. And the court goes back to the purpose of the hearing that they're having here at paragraph 40, says, with limited exceptions, a motion, and particularly one brought in the context of an application, is an interlocutory proceeding in which a court may grant interim relief. Here, the respondents purport to seek final relief on an interlocutory motion. So, interlocutory motion is one that's dealt with before the final trial. The final trial in this would be the trial on whether Mr. Skelly is guilty of any offenses against the Reopening Ontario Act. Here, what's being argued is that interlocutory order shutting down his business and whether it should be shut down or not. So what the judge is essentially saying is that his counsel put the cart before the horse. They haven't argued whether his business should have been shut down in the first place. They're going straight to saying he should be granted damages for his business having been shut down. Which again, that may seem overly formal, but this is court. Formalities is how the court works and how the court should work to protect your rights as well. So, paragraph 43, the judge says the problems are not minor or technical in nature. They cannot be overlooked. They go to the heart of procedural fairness in the court's jurisdiction. And that's what I just referred to, procedural fairness. So, here's the final disposition, paragraph 46. The motion is dismissed without prejudice to the respondent's ability to seek relief against Ontario under the Charter or the Constitution Act 1982 in a properly constituted proceeding or hearing. So, Justice Akbarali isn't just ending the case, you can't argue it anymore, you're done. They have the opportunity to go back, reframe the argument, give her what she wants, and then she's suggesting she'll hear it. So, again, I stand by my position that there's no evidence that the judge is corrupt, has received a payoff, or is just looking to get rid of them. It seems to be legitimate from what I'm seeing in the documents filed here. So again, I'm not looking to Monday morning quarterback anyone here. I just want to try to help viewers of Don't Talk TV understand a bit of what went on here. And although I may complain on this channel sometimes of things that I don't like or directions I don't like, overall, I think Canada has a very good justice system and one that is generally quite fair and just. Therefore, it upsets me when I see people all over social media saying our system is corrupt, this Justice Akbarali is crooked, she's paid off by the government or what have you, when there's no evidence of that. This appears to be the court functioning as it should, and I hope that this case will be heard on its merits when an application is made that meets the requirements that Justice Akbarali has. One final note, though, I think it's worthy of looking at the forms that are provided on the Superior Court of Justice's own website. So I looked up the rules of civil procedure, which are cited by Justice Akbarali. Here's the wording that the Notice of Constitutional Question format given in Section Form F under the rules is, saying that the party intends to question a constitutional validity of the legislation and claim a remedy under Section 24.1 of the Charter of Rights and Freedoms in relation to an act or omission of the Government of Canada. So it is, Mr. Scully's lawyers used the exact wording of the form. So I think there's a legitimate argument, well, hey, look, we used the form that the court posts on their website using their exact wording. Now, that form would seem to be deficient based on the ruling of Justice Akbarali, but there you have it. So this video is not legal advice. If you have a situation where you require legal advice, contact a lawyer. You can call myself or another lawyer. My number is listed below along with my website. If there's any topics you'd like to see me cover on this channel, please leave a comment in the comment section below or send me an email. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, and subscribing, and following me on social media.